So the Supreme Court has once again demonstrated that it's nothing more than a bunch of partisan hacks who are aiming to keep Republicans in power at all costs. Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So I've already reported a number of times about the steps that the Supreme Court has taken to try to undermine the Voting Rights Act, and basically to help keep Republicans in power no matter how the voters decide. Well, they really went above and beyond the call of duty in responding to a request by Wisconsin Republicans. You see, Wisconsin is a state, of course, that's a swing state at best. It was a state that was won by Donald Trump in 2016 and Joe Biden in 2020. It's one of the three critical Midwestern states, basically, that gave the election to Donald Trump, Michigan and Pennsylvania being the other two. Had these states, which were won by Donald Trump by the narrowest of margins, and then won by Joe Biden by the narrowest of margins, gone the opposite direction, then frankly in 2016 Hillary Clinton would have been president, and much of this nightmare would never have happened. Interestingly enough, all three of these states, though, despite having been won by Joe Biden, and despite all of them having Democratic governors, by the way, are controlled overwhelmingly at the state legislative level by Republicans. How do they do this despite the fact that they don't win the majority in the statewide contest? Well, they do it through gerrymandering, frankly. And these three states took advantage of a narrow window of opportunity where you had unified control of the government under the control of Republicans to gerrymander the crap out of the state and basically make sure that Republicans would always win the state legislative battles, no matter how people voted. I mean, according to an analysis by Madison.com, and the Wisconsin State Journal, Democratic candidates won 46% of the legislative vote in the 2020 election. But yet, they only got 38 out of 99 seats in the House. In state Senate races, you saw a similar result, with Democrats getting 47% of the total votes, but yet only ending up with 38% of the Senate seats. This is similar to the pattern that we see in both Michigan and Pennsylvania, by the way. And this result, combined with the aggressive efforts of the state legislature to essentially stop Democratic Governor Tony Evers from doing anything in Wisconsin, prompted Paul Krugman, the New York Times columnist, to quip that Wisconsin was like Hungary on the Great Lakes. So at any rate, early on in the redistricting process, there was an effort by Democrats to argue that the legislative map should be completely withdrawn. Democrats suffered a defeat in the state courts, which instead urged Democrats not to essentially redraw the map so that they were fairer overall, but instead to say that the legislative district should be as similar as possible to the 2011 map. So building upon that then, the Republican state legislature passed a map that was overwhelmingly gerrymandered to favor the Republicans. That's not terribly surprising. The governor, who has a pretty limited impact on the process, though, proposed a slight modification of this map that would essentially create one more majority-minority district in Milwaukee, aimed at essentially increasing minority representation in the state legislature. These two maps essentially went to the state Supreme Court, which decided that the governor's map was preferable given the Federal Voting Rights Act, which urges states to district to allow for greater minority representation. Now, let's be clear about this. This is a state legislature deciding on a state map based upon state law, with a state court ruling that one map was preferable to the other. Now, in our federal system, that should have been the end of the story. The highest court in the state of Wisconsin had ruled on which map was preferable, and although Congress might have stepped in if there were some issue with the congressional map that was drawn, because of course that impacts the federal government, we're not talking about any kind of federal interest in this process here. And remember, under our constitutional system, the federal government is severely limited in its power. Power resides with the states, and the states essentially have delegated certain powers to the federal government that the federal government can then exercise. Now, if you think that this is just some academic theory that we're talking about here, you have to understand the Supreme Court routinely strikes down laws of Congress because essentially they've overstepped the bounds of what the states delegated to Congress. I mean, that's been the argument that's been made against Obamacare, for example, in all the cases that have come before the Supreme Court. And frankly, it's been the basis that the court has used to essentially do nothing about the abortion laws that have been put in effect by the state legislatures in several states. So now we have a state issue argued between two bodies of state officials and adjudicated by the state Supreme Court. And again, that should have been the end of the story. But in this case, the U.S. Supreme Court stepped in and on their shadow docket essentially rejected the state Supreme Court's decision in favor of the governor's map and instead essentially implemented the legislature's map. Now, in any other circumstance, by the way, Republicans would be howling by now because this is clearly, number one, an example of the federal government overstepping its authority, and number two, the U.S. Supreme Court taking an activist approach to politics, exactly the type of thing that Republican senators were grilling Ketanji Brown Jackson about in her Supreme Court hearings. What's especially rich about this decision is the fact that the Supreme Court did not rule that there was any issue with the congressional maps that were drawn in Wisconsin. Those are the maps that have some impact on the federal government and where the Supreme Court might have a legitimate basis to step in. The place that they did step in were on the state legislative maps, which again have nothing to do with the federal government. Now, Sonia Sotomayor, in her dissent, bemoans the fact that this is so unnecessary, that what would have made sense is for the Supreme Court just to kind of say this has nothing to do with us. After all, in either case, Republicans still retain a decisive advantage in gerrymandering. But this just shows how aggressive Republicans are and how partisan the Republican Supreme Court is in its desperate effort to basically undermine the Voting Rights Act in any way that they can. The Voting Rights Act, of course, is the greatest threat that exists to the white supremacist authoritarianism that Republicans are so intent on supporting, because it basically insists on everybody being able to vote without restrictions, no matter what the color of their skin. And that is the greatest fear that the white supremacists have as America becomes browner and browner moving forward. Now, in one of the editorials in the Washington Post, the authors seem to argue that, well, this is outrageous, but at least the Supreme Court stood in the way of Donald Trump's ridiculous efforts to try to assert his authoritarianism in his effort to essentially take control of the U.S. government despite having lost the election. And here I don't really buy that argument, because the reality is that the Supreme Court justices didn't like Trump. The visceral dislike that especially the Chief Justice and Donald Trump had for each other was barely covered over. So the issue isn't that the Supreme Court doesn't want authoritarianism, especially one driven by white supremacy. No, the issue is that the Supreme Court wants an authoritarian, white supremacist government, just one that doesn't involve Donald Trump. I find it rich, the comments that we hear from Republican senators about how the Democrats are trying to essentially pack the court and trying to politicize it, when they've already done that. They just don't want us undoing what they've done. It's not surprising that public approval of the Supreme Court is at an all-time low. And you would have thought that under the circumstances, the conservative justices would have felt that, maybe now is not the best time to step in and take such an action that really, again, is so unnecessary. But these justices just could not control themselves. They have such venom and animosity toward the Voting Rights Act and toward anybody who doesn't have white skin. They're going to do whatever they can, whenever they can, no matter what the law says. Well, if you're concerned about the politicization of the Supreme Court, check out this other video over here that I did, where I talk about some of the ways that the Supreme Court is trying to undermine American democracy. I'll see you then. In the meantime, let's hope for continued progress. Thank you.